Election cases involving local elective officials. Galado v. Kumlik. Facts: Galado and private respondent Galeon were candidates during the January 1988 local elections for mayor of Garcia Hernandez, Bohol. Petitioner was proclaimed the duly elected mayor. Private respondent filed an election protest before the RDC. After hearing, the said court upheld the proclamation of petitioner. Private respondent appealed the RDC decision to the Kumlik. Its first division reversed the RDC decision and declared private respondent the duly elected mayor. After the Kumlik en banc denied the petitioner's motion for reconsideration and affirmed the decision of its first division. The Kumlik held that the 15 ballots in the same precinct containing the initial C after the name Galado were marked ballots and, therefore, invalid. Undaunted by his previous failed actions, the petitioner filed the present petition for certiorari and injunction before the Supreme Court and succeeded in getting a temporary restraining order. In his comment to the petition, private respondent moved for dismissal, citing Article 9, Section 2, Paragraph 2 of the 1987 Constitution, that final decisions, orders or rulings of the Kumlik in election contests involving elective municipal offices are final and executory, and not appealable. Issue: whether or not a Kumlik decision may, if it sets aside the trial court's decision involving marked ballots, be brought to the Supreme Court by a petition for certiorari by the aggrieved party. Held: yes. Ratio: the fact that decisions, final orders, or rulings of the Kumlik in contests involving elective municipal and barangay offices are final, executory and not appealable, does not preclude a recourse to this court by way of a special civil action of certiorari. Under Article 9, Section 7 of the Constitution, which petitioner cites, it is stated, unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt thereof. We resolve this issue in favor of the petitioner. The petition involves pure questions of fact as they relate to appreciation of evidence which is beyond the power of review of this court. The Kumlik found that the writing of the letter C after the word Galado in the 15 ballots of Precinct 14 is a clear and convincing proof of a pattern or design to identify the ballots and/or voters. This finding should be conclusive on the court. The Commission on Elections has exclusive original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials, and has appellate jurisdiction over all contests involving elective municipal officials decided by trial courts of general jurisdiction or involving elective barangay officials decided by trial courts of limited jurisdiction. Section 2, Paragraph 1 of the 1987 Constitution. In the present case, after a review of the trial court's decision, the respondent Kumlik found that 15 ballots in the same precinct containing the letter C after the name Galado are clearly marked ballots. May this Kumlik decision be brought to this court by a petition for certiorari by the aggrieved party? Under Article 9 Section 7 of the Constitution, which petitioner cites in support of this petition, it is stated, unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. On the other hand, private respondent relies on Article 9, Section 2, Paragraph 2 of the Constitution, which provides that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices shall be final, executory, and not appealable. We resolve this issue in favor of the petitioner. The fact that decisions, final orders, or rulings of the Commission on Elections in contests involving elective municipal and barangay offices are final, executory and not appealable, does not preclude a recourse to this court by way of a special civil action of certiorari. The proceedings in the Constitutional Commission on this matter are enlightening. We do not, however, believe that the Cumlic committed grave abuse of discretion amounting to lack or excess of jurisdiction in rendering the questioned decision. It is settled that the function of a writ of certiorari is to keep an inferior court or tribunal within the bounds of its jurisdiction or to prevent it from committing a grave abuse of discretion amounting to lack or excess of jurisdiction. As correctly argued by the Cumlic, it has the inherent power to decide an election contest on physical evidence, equity, law, and justice, and apply established jurisprudence in support of its findings and conclusions. And that the extent to which such precedents apply rests on its discretion, the exercise of which should not be controlled unless such discretion has been abused to the prejudice of either party. Finally, the records disclose that private respondent had already assumed the position of Mayor of Garcia Hernandez as the duly elected mayor of the municipality by virtue of the Cumlic decision. The main purpose of prohibition is to suspend all action and prevent the further performance of the act complained of. In this light, the petition at bar has become moot and academic. Facts: Juan Garcia Rivera and Juan Miter Garcia II were candidates for the position of mayor of Guinobatan, Albay, during the local elections in January 1988. The Municipal Board of Canvassers proclaimed Rivera as the duly elected mayor by a majority of 10 votes. Garcia filed an election protest with the RDC, which rendered its verdict finding Garcia to have obtained 6,376 votes as against Rivera's 6,222. On appeal to the Cumlic sustained with modification the judgment. It ruled that Juan Garcia was the duly elected municipal mayor by a majority of 153 votes over Juan Rivera instead of plurality of 154 votes. Upon MR, the Cumlic affirmed the decision. Garcia commenced to discharge the duties and functions of mayor of Guinobatan on October 10, 1990, by virtue of a writ of execution implementing the Cumlic decision of September 6, 1990. He continued as mayor until November 10, 1990, when he was served notice of this court's temporary restraining order, issued upon Rivera's motion. In this petition, Rivera prayed for the issuance of a restraining order, arguing that the judgment had not yet become final and executory. He cites Article IXC, Section 2, PAR of the 1987 Constitution, in relation to Part 7, Rule 39, Section 1 of the Cumlic Rules of Procedure. He also contends that since the Cumlic decision has not yet become final and executory, the Cumlic has no authority to issue the assailed order and writ of execution. Petitioner maintains further that he has a period of 30 days from September 6, 1990 or until October 6, 1990 within which to elevate the Cumlic decision, on certiorari, to this court, pursuant to Section 1. Rule 39 of the Cumlic Rules of Procedure. He submits that the questioned Cumlic decision is not one that became final and executory unless restrained by this court as provided under Section 3, Rule 39 of the Cumlic Rules. As said rule applies only to decisions in pre-proclamation cases and petitions to deny due course or to disqualify a candidate, and postpone or suspend elections. Lastly, according to petitioner, Section 13 of Rule 18 and Section 1 of Rule 39, review by the Supreme Court of Cumlic Decisions. Orders and rulings, of the Cumlic Rules of Procedure, should be read in the context of Section 7, Article IXA of the Constitution. Garcia contends that the Constitution declares that the Cumlic decision on election contests involving elective municipal and barangay officials are to be final, executor and not appealable. Issue 1. The decisions of the Cumlic in election contests involving elective municipal and barangay officials, being final and executory and not appealable, preclude the filing of a special civil action of certiorari. Held yes ratio, under Article 9, Section 7 of the Constitution, which petitioner cites in support of this petition, it is stated, unless otherwise provided by the Constitution or by law, any decision, order, or ruling of each Commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. On the other hand, private respondent relies on Article 9, Section 2, Paragraph 2 of the Constitution, which provides that decisions, final orders, or rulings of the Commission on elections in contests involving elective municipal and barangay offices shall be final, executory and not appealable. We resolve this issue in favor of the petitioner. The fact that decisions, final orders, or rulings of the Commission on elections in contests involving elective municipal and barangay offices are final, executory and not appealable does not preclude a recourse to this court by way of a special civil action of certiorari. The proceedings in the Constitutional Commission on this matter are enlightening. Flores vs. Cumlic. Obviously, the provision of Article IXC, Section 2 of the Constitution that decisions, final orders, or rulings of the Commission on election contests involving elective municipal and barangay offices shall be final, executory, and not appealable applies only to questions of fact and not of law. That provision was not intended to divest the Supreme Court of its authority to resolve questions of law as inherent in the judicial power conferred upon it by the Constitution. We eschew a literal reading of that provision that would contradict such authority. Actually, the main thrust of the present petition for certiorari is that the Cumlic and Bank committed grave abuse of discretion when it affirmed the decision of its First Division, promulgated on May 2, 1990. Annulling the proclamation of the petitioner as the duly elected mayor of Guinobadan, Albay, and when it did not exclude from the total votes of Garcia at least 10 votes which were allegedly misappreciated in Garcia's favor. We have closely scrutinized the challenged Cumlic decision and find that the said decision was not arrived at capriciously or whimsically by respondent Cumlic. A painstaking re-evaluation of the question 67 ballots was made by the Cumlic and Bank. In fact, 14 ballots originally adjudicated in Garcia's favor were overruled by the Commission and Bank, thus reducing the number of votes in his favor to 894 votes out of the 2,445 contested ballots. On the other hand, 16 ballots were added in Rivera's favor, thus increasing the votes in his favor to 1,087 votes. Moreover, the appreciation and re-evaluation of ballots are factual determinations. It is settled that in a petition for certiorari, findings of fact of administrative bodies are final unless grave abuse of discretion has marred such factual determinations. We find none in this case. Regalado, concurring. What the foregoing observations actually boil down to is that the decisions, orders, or rulings of said constitutional commissions are not subject to appellate review, that is, with this court acting in the exercise of appellate jurisdiction and exercising its power of review over alleged errors of law and, sometimes, of fact or both. Such decisions, orders, or rulings are not, however, invulnerable to an original civil action of certiorari, prohibition, or mandamus invoking the original jurisdiction of this court. Under its power of control and supervision over the lower courts, to pass upon errors of jurisdiction imputed to said commissions. This is inevitable and justified because no appeal or any other plain, speedy or adequate remedy in the ordinary course of law lies from said adjudications. Narvaeza, dissenting, it bears stressing that the final, executory and unappealable character of the Cumlic's rulings, orders, or decisions in election contests involving elective municipal and barangay offices is pronounced not by statute or presidential issuance, but by the Constitution itself. This is a relevant consideration because while Congress is granted by Section 2, Article 8 of the Constitution the power to define, prescribe, and apportion the jurisdiction of the various courts, may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 of the same Article 8, and said Section 5 declares it to be one of the powers of the Supreme Court to review, reverse, modify, or affirm on appeal or certiorari, as the law or the rules of court may provide, final judgments and orders of lower courts in It is in truth this fundamental limitation on the legislative prerogative to define, prescribe, and apportion the jurisdiction of courts which is that the Supreme Court may not be deprived by law of jurisdiction over certain particular cases that underlay this court's doctrines, allowing review by the special civil action of certiorari under Rule 65 of Judgments and Final Orders of the National Labor Relations Commission under the Labor Code, and the Central Board of Assessment Appeals, from which no appeal is prescribed by law. It cannot be gainsaid, however, that while Congress may not deprive the Supreme Court of its constitutionally stated powers, that self-same Constitution may itself effect that deprivation. And this appears to be precisely the purpose and intent of said Section 2, Article IXC of the Constitution as written, to remove from this court's power to review, revise, reverse, modify, or affirm on appeal or certiorari final judgments and orders of the Cumlic in election contests involving elective municipal and barangay offices.